State of Florida versus Sarah Boone, 2020 TF 2603, State of Florida.
Well, guess who's back in court? And I guess you all know whose sweet face that is. Our little friend, the suitcase killer, Sarah Boone, in Orlando, Florida area. Sarah's looking pretty good. Looks like, she might be sober, Sarah, now. Good for her. But guess what? They want to move the trial back again. Let's listen in.
Where do you stand in preparing to proceed forward to trial?
State's ready, Your Honor.
Mr. Banquets, where do you stand in regards to preparing for trial?
The defense is not ready. We're requesting a continuance. We are having difficult time finding an expert who is willing to work for the JAC rates. And so I'm still it's an essential part of the case, basically. It's never been initiated before by any of the prior attorneys that I'm aware of.
In broad terms, what's the nature, what's the field?
Spouse defense.
Okay.
Statutorily, we have to give the state notice, sufficient time, and name of the expert and the essential elements that they'll be testifying to.
How deeply have you plumbed the depths of the pool of experts in this field to find out or find one who's willing to work for the JAC rate?
Well, I've actually talked to 3, and but they don't have contracts with JAC and are not willing to work with JAC. And I've made some other inroads with battered women's shelters, trying to get their psychologists, who'd be willing. Problem is willing to testify, basically.
Okay. Because of the concern about the compensation rate for testimony?
Well, that's one of the things. And to be honest with you, this case has had so much notoriety that people don't want to be involved.
Okay.
If I could ask of the defense, because I think it would make a difference in the timing of the continuance in this case, does the defense intend to hire an expert to testify generally as to the precepts and the things that go along with battered spouse syndrome, or do they intend to hire an expert that will evaluate Mrs. Boone and want to comment on her directly? And the reason I ask that is because I think the case law is clear that if it's the latter thing, then the state is entitled to have her sit down with our own expert to be evaluated as well. So that would obviously take more time if that is going to be the path they're going to go.
Mr. Banquets, are you in a position to distinguish?
Number two is definitely what we're looking at, Judge. Although number one would be incorporated in that, as far as their general ability and their expertise in the area.
Would you agree that if in fact you retain an expert and they're going to opine specifically on Ms. Boone's state of mind at the time of the incident, that opens the door for the state to also
most
have
definitely.
an expert? All right.
Most definitely.
So here's what I am, and Mr. Castro, let me ask you this. Let's say that turns out not to be an issue. We're not going to have 2 experts. How long would it otherwise take you to present your case? Just rough idea.
I would say 3 days.
And other than this potential defense, Mr. Banquets, and is that including jury selection, Mr. Cacciatore?
No, I probably 3.5 days with jury selection.
All right. And Mr. Banquets, other than this potential defense, if we picked a jury in 1 day, the state presented their case in 2.5 days, how long do you anticipate a defense presentation would be at this point?
I'd say at least 3 days.
Okay. So here's what I'm thinking. I'll grant the continuance. I'm thinking continuing out to the July 11th pretrial, July 24th trial period.
How long is that trial period, Judge? I have a time certain death penalty case in Lake County starting the second week in August.
That's a 3-week trial period, so it'd be the week starting Monday, July 24th, Monday, July 31st, and then the last week of the trial period would be Monday, August 7th.
That's when I'm scheduled to start picking a jury in Lake County.
Well, let's do this. I want to set it for that date. That way you'll have a much better idea of what's actually happening on your death penalty case in Lake County. I understand that they're priority cases, but I also know that they're the cases where if a problem comes up, a judge is, no matter what a judge has said before, they're likely to allow the case to move because they don't want to try it twice.
Just to advise the court, this case had to be continued at the last minute because of one of the attorney's wives basically had a stroke. And so it was a week before we were scheduled to start in that case. But Judge Davis up there, now that has, I won't say resolved itself, but is in a better position. Judge Davis has advised all of us that we're going, quote, come hell or high water.
See, I try not to say things like that because I feel like I'm just tempting
Well,
fate.
that's just Lake County, Judge. What do you expect?
Well, having never worked there, it means nothing to me. So, I'll grant the change, July 11th pretrial, July 24th trial period. And let's go ahead and do this. While I'm giving July 11th as the date, let's go ahead and have the lawyers reach out to my judicial assistant and just like we did this time, schedule
A status.
a status separate, unique date for pretrial so that I have, y'all have my undivided attention when we talk about the case. I don't have 97 other lawyers tapping their fingers.
Well, there you have it. July 24th, you guys, over 3 months away. Can you believe it? I mean, I understand why they want to do it. I totally get it. It seems reasonable what they're going through. We'll keep on top of this one, and I guess we'll see you guys back in July in regards to Sarah. And until then, keep looking for updates on the West trial. And next week, the Stout trial begins. It's gonna be a big one. See you guys then. Well, everyone, no shocker here, I guess. All right, so this morning, watching Court TV, because that's the only place I could find it, they had a pre-trial meeting, I would say, for Sarah Boone. And not a shocker, but we're looking at another postponement. Apparently, they're still having trouble finding funding for the experts. It's having to do with, like, they found somebody, but it's a matter of when do we get the money to, it's confusing to me because it's all state funded. But anyway, they've pushed it back to a status conference on Friday, July 21st, which means that original trial that was scheduled to start with jury selection on the 24th is probably going to also be pushed back. So just a little background. She is now on her 6th attorney. This started in February. And she's already gone to 6 attorneys. She's written various letters to the judges. She's written various letters to the attorneys. She was not in court today. In fact, both her attorney and the prosecuting attorney appeared via Zoom in the courtroom. So it's not like if you didn't see it, you really missed a whole lot. Her and Torrez, whom she's suspected of unaliving in the suitcase, started dating back in 2016. It looks like about 2018, a lot of police calls to their residents, back and forth, accusations of domestic, you know what I'm saying, some domestic battery, I guess is what I guess I'm allowed to say that on YouTube. There's been times when he's been arrested. There's been times when she's been arrested, and there's been times when they've both been arrested when the police have been called. Now, I don't know if the neighbors are calling. It looks like on some of these incidences, they themselves actually called the police against each other. It's a crazy trial, you guys. She's gonna use that domestic spousal abuse angle. That's what her attorneys are leaning towards. That's why these experts are so key. And that's why they really can't do anything until then. So I just wanted to keep you guys updated, let you know where I'm at, where we're at. And until we get more, we're going to have to put little Miss Suitcase Sarah to the side until they can figure out and get their ducks in a row. And then we'll resume following this trial. Thanks for watching. Guys, have a blessed day. Hi, guys. I'm back because you know what? There's been an update in the Suitcase Sarah Boone trial. Apparently, they have reached some discussions today. I almost completely forgot it. They were meeting again today, her attorneys, because remember, last time they went back in, it was like a pretrial, and they delayed it again and said, "Oh, we still don't have the psychiatrist wanting to work with her. We don't have the money to pay for it." Blah 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 blah. So, latest update. Basically, the trial for a Florida woman accused of zipping her boyfriend into a suitcase and leaving him to die after a game of hide and seek has been delayed until October the 2nd of this year. Ooh, that's a long time away. The trial was originally set to begin on Monday. There were 2 more hearings scheduled for September. On September the 17th, officials will meet to determine whether an expert will be approved and paid for. The other September date is for Boone's next pretrial hearing. Boone is facing a charge of second-degree homicide in the death of her boyfriend, Jorge Torrez Jr. In February of 2020, she called 911 to report Torrez was unalive inside their apartment in Winter Park, Florida. She told 911 dispatchers that she and Torrez were playing a game of hide and seek the night before, and during the game, both jokingly thought it would be funny if he got in the suitcase and she zipped him up. Well, long story short, if you haven't seen my past videos on this, you'll just have to go back and watch them because homegirl zipped him up in the suitcase. They were wasted on alcohol. She left in there. She recorded a video of it. And then, which, I mean, conviction right there. If you guys see this video, it's horrible. But there's a lot of things going on between her and this guy. There was a lot of domestic disturbances, calls, and things like that going on. And it's kind of questionable. I think it was kind of a back and forth thing. I think they were both to blame in all these domestic disturbance calls. So anyway, we know that she was a heavy drinker. It seems like there was probably some addiction to alcohol involved as well. So ahead of the trial, the state released the body camera video from the scene and her infamous interview where she said it was not intentional. It was not intentional. I think I remember hearing that from Jarrell Brooks too. Maybe I should do a clip video of putting all that stuff together. Anyway, I guess that's it. I just wanted to let you guys know we've got now it's pushed back till October, and maybe we'll meet up in September and see how the pretrial is going. She has written several letters to her attorney and the judge, and she wants updates and she wants to be a part of these pretrial hearings. So if it happens and it's streamed, I'll be on it. Well, good morning, everybody. How are we today? Happy Friday. It's the weekend. Here we go. He's so tired of her. Hi, people. Good to see you guys this morning. It hasn't started yet. Oh, well, thank you, CB. Thank God I didn't miss it. I am not. Whew. I'm so unorganized today. I haven't had enough coffee, I guess. I thought I had my ducks in a row. And then one of them went just waltzing off on me this morning. I think the security guard is asleep. Shelly, you're probably right. Sean, she's looking rough. She looks a lot rougher than she did, but you know what? She's got to look tough in prison or she'll get eaten up in there, probably. That would be scary. And she's a heavy drinker, so, you know, that'll do it to you, too. She looks older. Barbara, how much time do you think she's aged since being arrested? For hyping you guys. Somebody's not happy. At least 8 years, Shelley, you think? I gotta re-download that WebEx thing, you guys. I'll have to do that some other time so we don't have to depend on somebody else to review this, but I apologize. I had my computer, all these I've got to get some more RAM or something or whatever they call it. I need some computer help. I got too much junk on my computer. How old is she, Barbara? You say she looks 45, but how old is she? I forgot. Isn't she late 30s? I know her son's like, she's got a young
One of the
son.
assistant state attorneys reach out to Mr. Cacciatore and see if they object to you standing in on the motion to withdraw.
Judge, I do see Mr. Cacciatore online.
Correct.
It's just virtually.
He's going to be able to see us doing work. He's not going to be able to hear us doing work.
I'll call him, Judge.
Okay, thank you.
Stephen H. Hey, Stephen. He says 47.
Judge, also JAC is on the line.
They are.
That's on the motion for appointment of the expert.
I understand.
Oh,
Thank you, though.
they've been waiting on that. Look, he's got a walker, you guys. I didn't realize he had a walker. They've been waiting on that JAC thing. That was what was holding everything up for the last couple of months, getting that money approved to get her, what do you call it? Her witness paid for, since they're going after the whole defense that she was a battered woman. I think her attorney's age too, though. You guys, since he got on thing with her. I don't know what the lag's about, but her attorney basically was saying that I'll shut up if they start talking. He was saying that he had this big criminal case, death penalty case that he was part of, that he'd been working on all full time and on weekends. So he's admitting that he wasn't giving her case any attention, which is weird. But then one of the attorneys on YouTube was saying that he thought it was unprofessional, the way that he handled the withdrawal motion, saying that no attorney would be good enough for her and she needs to defend herself. Why did they just mute it? Did they just mute it because she was talking? Oh, come on now. Don't mute us. Okay, here we go. So they're trying to get the JAC who has to prove the money or whatever, and then they have to get the attorney or for the other or the prosecutor on. Prosecutor's probably sick to death of this case, you know? But wait, who's that sitting over there then? If he's not in the room. Kathy, he does look like he needs to retire. Bless his heart. You guys, I haven't muted this. I don't know why we're not hearing anything. Okay. We're all right. He has been around long. Yeah, Tina's from the area. Tina's kind of got the in. He just called the case. We can't hear it though. Something wrong with the stream. So that guy's our seventh attorney. Which one? The one in the white? The one sitting down in the lower right-hand corner, that's her current sixth attorney that's trying to get the heck out of Dodge. See, Shelly, I think their mics are muted too. I think they automatically muted it. Oh, this looks good. Tina, quit teasing us, girl. Stop it. I think they are having tech problems with the Zoom. I think they are too. And WebEx is not going to download for me right now. So here's the thing. If we miss anything, we'll go back and rewatch it. We'll be able to go back and get it. Here we go.
Testing, testing. Eric, can you hear me inside the meeting room?
We can hear you now, or we could.
Check, 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 check. Eric, can you confirm that you hear me now? Perfect.
All right, come on.
All right, Judge, you're all set.
Right.
Let's do this.
For those of you appearing virtually, my apologies. We've been troubleshooting a system problem this morning. It appears that we have now resolved that. Let's go ahead and call up the Boone case.
State of Florida. 2603, state.
Dave Cacciatore on behalf of the state.
Please raise your right hand. Do you solemnly swear or affirm that the testimony you shall give should be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Can I have JAC announce themselves as well?
Yes, Audrey Moore for JAC.
All right. So we have multiple matters scheduled this morning, one of which is Mr. Bankwitz's motion to withdraw. My reading of the law is I feel like I have to address that motion first and rule on that before I can address any other motions that would be heard today. So,
yeah.
Mr. Bankwitz, I'll start with you. Tell me why you're moving to withdraw.
Judge, the letters that have been coming to your honor, the derogatory berating of my services in this case, I can't effectively represent her. She doesn't trust me. She calls me a dud, I think, a buffoon, on and on and on and on. And no one should have to endure that type of derogatory comments and expect to effectively represent someone, especially in a murder case.
Ms. Boone, I read your letter dated August 26, 2023, and your letter dated August 30th, 2023. And just so we're clear, I read all of the letters that you send to the court. Whether I respond or not is based on what's in the letter and whether I'm asked to actually do something that's within my purview as a judge or not. If I understand correctly, you have now decided that you think it would be best, in fact, if Mr. Bankwitz was allowed to withdraw. Is that correct?
Yes.
All right. And you understand by him withdrawing, I'll have to appoint another attorney. Do you understand that?
Yeah.
And that attorney's not standing here, so we're not going to be able to address, and I'll give the state a chance to talk to me as well. But assuming I grant this, we won't be able to address the other issues that were docketed for today, which means I'm going to have to reset your case for a later date. Do you understand that?
I'm not sure what items it is you're speaking of. I haven't received a copy yet of the letter.
So we're having a hearing today in regards to authorization for payment for an expert that your attorney believes he needs to defend you and issue about the compensation of that expert, which is why JAC is participating today. I don't know if your next lawyer is going to think that that expert's the right person to use, or whether they're going to go a different route after. And even if they did, they're not standing here. And once Mr. Bankwitz is out, he's out. He can't argue the motion. So do you understand that?
I fully understand.
All right. Mr. Cacciatore, normally the state takes no position in these issues, but there are limited circumstances when the state doesn't take a position. So are you taking a position on this motion withdrawal, Mr. Cacciatore?
No, or we would be not taking a position.
All right. So I'm going to grant Mr. Bankwitz's motion to withdraw. I'm going to appoint, find my list, Attorney Winston Hobson to represent Ms. Boone. In regards to the other matters scheduled today, I'm going to take no action on them at this time until Mr. Hobson can, well, in regards to the motion involving JAC, I'm simply going to take no action on that motion at this point in time until Mr. Hobson has a chance to review it and determine whether he wants to proceed with that motion. I will address the pretrial because today was also supposed to be pretrial. Here's what we'll do. Let me just get my calendar up. As far as pretrial conference, I'm going to set this case for pretrial conference on Tuesday, November 28th, and a trial period starting Monday, December 11th. I think any earlier period of time would be unrealistic for Mr. Hobson to get on board, get up to speed with the discovery, and determine how he wants to proceed in regards to any experts. But I will set a status hearing on the case prior to that.
Dang, now I gotta change all my live streams. Yeah, that attorney's gonna go have a drink after this. Probably with the judge. No, I'm just kidding. I don't know that for a fact. Run, Winston, run. Shelly. Hobson. Oh, Hobson. Okay, thank you, Tina. With Miss Walker. I feel bad for the attorney. I kind of do. I mean, you know. But
I'll set a status hearing on the case Monday, October 30th,
October 30th.
2023. at 10 a.m.
That's 9 a.m. my time.
That'll be for the purpose of making sure that Mr. Hobson's on board, some sense of where he thinks things are, how realistic he thinks the November pretrial is, any other matters I need to address with him at that time. Now, Ms. Boone, in just a minute, they're going to take you back to the Orange County Jail. I'm going to suggest that you talk to Mr. Hobson about the various other issues you raised in your letter dated August 30th, 2023. One other thing I want to talk to you about, we had this conversation once in the past.
Get her.
Clearly, your working relationship with Mr. Banquets was such that it deteriorated to the point where the two of y'all just couldn't work together to defend your case. So I'm not going to try to referee
It's not his
how
job.
that played out, why that unfolded the way it did. But one thing I want to caution you about, if this becomes a problem on another court-appointed attorney, I'm going to look more closely. Disputes are, you have a right to a court-appointed lawyer. There are certain decisions a defendant gets to make in the defense of their case that are absolutely theirs, such as whether they go to trial or not, such as whether they testify or not. But there are many decisions in a case that a lawyer gets to make. And while you certainly have a right to consult with your lawyer and discuss with your lawyer, they don't automatically just do whatever you say. They use their professional judgment and experience and look at the evidence, look at the law, and do the best they can. Also, you've got court-appointed counsel. As I've explained to you before, court-appointed counsel rarely have the luxury of representing one person and only having one case to focus on. I have concerns that your expectations of what any court-appointed counsel might do as far as spending time with you and the depth and degree of communication may be unrealistic expectations.
No.
You always have the right to retain a lawyer to represent you, and then that's between you and that lawyer. You can demand whatever expectations that you have as part of that agreement. But when it's a court-appointed lawyer, you have to accept and understand that they have other cases, other courtrooms, other responsibilities. And I'm cognizant of that when I'm addressing these types of issues about communication. So that's just food for thought, nothing to do today. I don't need a response from you. I just wanted to make sure you were aware of that and were thinking about that as we proceeded forward. So again, the court minutes reflect that I'm court continuing pretrial. I have granted the motion withdraw. I have appointed Mr. Hobson to represent the defendant, and I'm taking no action on the motion, the ex parte motion for cost directed where JC is responding. Ms. Boone will be returned to the Orange County Jail pending disposition of her case.
Thank you, Judge.
All right.
I'm not able to say anything.
No. he said no. Sarah, go to your cell and shut up. Take her pen away, for crying out loud. Take her pen away. No more letters. Her smile is inappropriate. You're right, Charlotte. You are absolutely right. All right, let me take this off the stream. You guys. She said, am I able to say anything? And he was like, no. I think you've said enough, Sarah. It's time to sit down, Sarah. No more paper and pen for you. They need to get her like an iPod or something and they'll let her just listen to some music. That Light's haircut is harsh. Oh, that haircut is harsh. Honey. All right. Let's go back to these letters, you guys. All right. So he referenced the August the 26th and the August 30th. She'll write in blood on toilet paper. Charlotte. That is awful, but I love it. Oh, okay. Hi, everyone. Shocker, I'm back. Okay. So I was going in to update my dates on my calendar for Suitcase Sarah, and guess what? Her new attorney is making things happen. He's adding things to the calendar. He's corresponding with the judge. Let's see what we got first. First up, we got a trial date set for Monday, December the 11th of this year. Of this year. Can you guys believe that? That really surprised me. And they're going to do the pretrial on November 28th. Oh, is that like, oh no, that's the Tuesday following Thanksgiving. So sounds like after Thanksgiving, we might be spending a little bit of post-holiday time together, you guys. So plan, thoroughly on your calendar between Thanksgiving and Christmas. We're going to be spending time here watching this trial together. Get your Christmas shopping done early. You're not gonna have time for it. You're gonna have to be right here with me. All right, what else did they do? Let me change this. All right. Another thing that I thought, this is where they basically they appointed him on the 8th. Make sure I can see what I'm doing here. Okay. So they appointed the new attorney that same day. It was the 8th was the last day that we were on a live stream with her. And the judge said, she said, "Can I say something?" He said, "No." No. Go back to your cell, Sarah. And the new attorney, this is his name. Yeah. I think I'm gonna have to blur this because I don't want to dox him, but you guys are gonna know who he is. His name's Hobson, and I did already talk about his name a little bit already. So anyway, so they got that taken care of. She claimed to be what they call it, an indigenous. On the 8th, they did the court hearing minutes from that date. They set the pretrial conference dates. They declared the defendant indigent, and appointed counsel. Then this other thing came up where I was like, whoa, Nelly, what is this? This was also attached. So if I'm looking at this properly, oh wait, is it up here yet? Hang on. Can y'all see it? Yeah, y'all can see it. Okay. So if I'm looking at this properly, somebody who appears to be an Orange County Sheriff's Office officer is being brought in for or being called to the carpet for matters related to unsatisfactory performance. What is that all about? What is that all about? You guys, are we going to get a letter pertaining to this, do you think? Are we going to find out what's going on here? Now, that was sent by email on the 8th of September, 2023. So it happened the day they had their trial. Now, on my previous notes, I had set that today they were going to meet up to do a pretrial conference. And it does still say on the court docket that there was 9:20 was still on there, that they were going to do something, but they didn't. No, but they don't have anything. I looked it up. I didn't see any news coverage on them meeting up. So that's from the old one. She did on the 16th. They can't. Okay, that's what they did. They canceled it. On the 15th, they canceled the upcoming status hearing. On the 16th, a written plea of not guilty and a waiver of arraignment. And I'm not an attorney, so I'm not even going to try to go through all that. But anyway, most of you guys know what that means. All right, so then we've got them talking about 10/2 for another hearing. So I did have October the 2nd written down for another hearing. So that's I guess the next time we're all going to meet up and talk about things. But I want to know what's going on with this. It's got to be a police officer. The way they word it is a witness in this prosecution. She is under investigation by the Orange County Sheriff's Office professional standards section, which that's what makes me think that she's for matters related to unsatisfactory performance. So I wonder what that's about. Wonder what's going on there. Is it a coincidence that it was done the same day he was assigned, or what? Or did something go down after the trial, after the hearing, this last hearing, and we don't know anything about it yet? Maybe we do want them to give her pen and paper back so we'll know what's going on. Anyway, just wanted to update you guys on that. Let you guys know that new attorney's he's got the ball rolling. He's on top of it. He's trying to make things happen for good old Suitcase Sarah. So we'll come back to that on the second, yeah. Looks like someone may be accused of Brady violation. A Brady violation, okay? See, you guys know more than I do about this stuff. Why don't they offer her a plea? It's like she's trying to stay in county as to avoid long-term prison. Hey, Coffee Cake. Hey, Kathy. Let's see. Hey, Christine. Hey, Rosebud. Yes, Rosebud, you made a live, and this was me jumping on here just to do a quick update on what was going on with Miss Suitcase Sarah. So, not a whole lot. We just have dates now. Let me go back and put those dates up so you can see them. In case you're late coming in. So, yeah. And I was reading through like the trial schedule, like all I forget what they call it, where they set up the trial and tell everybody this is what we're going to do. And I didn't see anything about televising it, but it's Florida, so we're pretty certain this is going to be. They've got to be putting this up, right? We're going to see this. I just can't see it not happening. So December 11th should be interesting, right? All right, so I'll get some more attorney lingo and all that good stuff for you guys for the next time that I have a live and I talk about lawyer stuff, okay? Don't be mad at me. I just wanted to come on and let you guys know that there had been some updates on the dockets and to let you know what they were all about. So we'll see what goes on. We'll see what happens. And I'll see you guys on December the 11th pertaining to this case right here. Y'all be good. Stay safe. Talk to you soon. Bye.
Are we ready to address Miss Boone's case?
Yes, we are.
Let's go ahead and call up Miss Boone's case.
Here we go.
State of Florida versus Sarah Boone, 2020 CF 2603. State
Dave Ketchner on behalf of the state.
defense.
Booth, Judge?
Move Miss Boone to the center seat and swear her in.
Please raise your right hand. Do you solemnly swear or affirm that the testimony you shall give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Welcome back, ma'am. Tell me your name and your date of birth.
Sarah Boone, 10-10-77.
All right. In this case, you were most recently represented by Mr. Bankowitz. I granted a motion to withdraw. We appointed Mr. Hobson and we set a status hearing today. Mr. Hobson, where do you stand as far as entering the case? And how much work do you think you have to get done to get the case ready for trial?
Let me start. I'll start at the back end, Judge. I would ask the court to set a status for sometime in January. I've had discussions with Ms. Booth before today, and she's okay with that. And I think that would make sense. I've got like a banker's box and a half of stuff I'm trying to wade through, plus the media stuff. So I think that would be the best option we've got right now, as far as I'm concerned.
So I don't have my dates, other than my pretrial and trial dates for next year. I don't have the calendar ironed out.
Okay.
But what I could do is just give y'all a January pretrial date, understanding that you're not representing that you're actually going to be ready to
Right.
announce trial. But at least it's a next point
Good
to see how
gracious.
far you've gone, how much further you have to go. My hope would be in January, you'd be able to give the court a realistic estimate of when you would be ready to announce trial.
Yes, sir.
State, are you okay if we handle it that way?
Yes, that sounds reasonable.
I have a January 16th pretrial date. Is that far enough into January, Mr. Hobson?
Yes, sir.
All right, here's what we'll do. We will set pretrial conference on January 16th, trial period January 29th. The one thing I'm going to ask Mr. Hobson is if there are particular problems with the discovery, getting up to speed that you know about before the 16th, if you could bring those to the court's attention beforehand.
Yes.
So we can at least start working those problems as they arrive, that would be my request.
Very good.
All right,
I would also ask the court as a caveat to indicate that it's a pretrial conference / status conference.
sure.
So-
Have the court reflect that I'm setting it for pretrial conference / status for the defense to advise the court how long before they are prepared for trial.
We're treating this as a defense motion to continue.
I think speedy trial was waived long, long ago.
4 years on, Judge.
Okay, so I'm just going to court reset it for those dates.
Yes, sir.
Anything else I need to do on Ms. Boone's case today?
Nothing else, Your Honor.
All right, Ms. Boone will be returned to the Orange County Jail pending disposition of her case.
Yes,
you.
thank you, Judge.
All right.
That's all I have. Have a good
Okay,
day.
have a good day. Ms. Vega, are you ready on Hope? All right, let's call up Hope.
Did y'all hear that?
State of Florida versus Hope Smith, 2023 CF 4674. State
Senior Escola.
defense.
Did y'all hear that? She said, Your Honor. Your Honor. He was like, no. Go back to your room, Sarah. Go back to your cell. Well, that was it, guys. You know what? I'm pulling it up to see if Fox is going to do anything. Give us a video view of everything going on this morning, but I don't see anything. So audio is all you can get at this point, but at least we got audio, right? We know exactly what's going on now. But we kind of figured she wasn't going to be able to talk. He was going to shut her down. Did y'all hear? Did you hear her say, Your Honor? He was waiting on it too. He didn't even respond. Hi, everyone. How are we? Oh, my word. Okay, I know this has been going on for the last week, the last couple of days here. We've known that Sarah knew it. Her current attorney is wanting to, well, he's wanting out. He's done. One letter and he was done. I was holding out to see what was going to happen. They met in court this morning. So, check this out. Because she was there and she was very vocal. And if you don't know who Suitcase Sarah is, you need to go back and watch the video I have on her from the beginning. It's in the playlist on my channel for Suitcase Sarah. Oh, and by the way, my new name for her is not just Suitcase Sarah. It's Psycho Suitcase Sarah now because I'm done with her. I've had it.
Sarah Boone's been through a lot of lawyers. In fact, this is now her 7th attorney, her last one saying that she wanted him to do things that he wouldn't do.
I've been here for 4 years and I'm tired of being here and I'm tired of going through all of these attorneys, which are not my fault.
Since then, Boone's trial has been delayed repeatedly as she gets into conflicts with her lawyers, something the judge in her case noted.
Seemingly all of your relationships with counsel have deteriorated.
Boone often writes letters to the judges complaining about her lawyers. Attorney Winston Hobson was appointed back in September, but asked the judge to let him withdraw, saying they're at loggerheads and she makes difficult demands.
I would say Ms. Boone has some ideas about what should be done, should not be done. Don't agree with those. Some things she wants done, I won't do.
But when 100 days have passed and I haven't heard or said or done anything other than try to figure out where you are because your phone doesn't work, I'm not a bad person because of that.
The judge gave Boone a new lawyer, but did not push back the trial, which is currently set to start in May. At the Orange County Courthouse, Bob Hazen.
She is not a bad person because of that. It was not intentional. It was not intentional that she just ran off her. I don't know if that was 7 or 8, y'all. I want to say this new person, which by the way is a female, woohoo, is 8. This is number 8. Can you believe this? There has got to be a limit. Can someone Google it for me, please, and tell me if there is a she is a Karen. You guys, oh my gosh. I cannot believe this. So here's what I think this new lawyer should do. She's obviously probably familiar with the case. And she's probably on top of her game because she's a female. Just got to say that. Okay. If I were her, this is what I would do. I would send Sarah, I would sneak in a case of wine to Sarah and keep her good and sloshed up until the trial begins. And maybe, just maybe, she'll shut up and stop writing letters until they can actually go to court. Now, according to the court docket, which let me share this with y'all. We're going to go over this latest letter too, by the way. So this morning I went in and I was like, okay, what's going on? He sent a motion to withdraw on the 1st of February, the old attorney, well, the latest attorney, this poor man. Finally, they had a hearing this morning, and that's where we heard her going on. Can we hear that again, please? I am not a bad person. I am not a bad person. And she's tired of it, y'all. She says she is tired of it. I got to hear that again. Hang on. Let's find that part. It is not her fault. She is not a bad person, and it was not intentional. Good Lord. I have never in my life. I have never. Oh, in my, how's my stream? Is it coming through okay for you guys? She is an narcissist. She's the strangest thing I've ever seen in my life. So here's his motion to withdraw. Well, this is the notice of the hearing for today. And then they did this, his reason for the motion to withdraw was irreconcilable differences, including but not limited to ethical considerations, have arisen in this case between the defendant and counsel, and it is the best interest of the defendant that counsel be allowed to withdraw and the case reassigned to another counsel in his stead. You know what? Like, this guy, he wasn't going to take the crap. He probably came in like one letter and I'm out. He probably came in with that kind of, he said he did meet with her at the jail and in video visits, and he has continued the work begun by his prior attorneys, her prior attorneys in the matter, all 6 of them, and has also consulted with experts to that's right, because not only do you have to get up on top of what's going on, but you also have to get on top of what's going on with these experts that they had scheduled. That took forever to get the experts up and going. If she would have not kicked out her first attorney or ran him off, or not her first, but her 6th, then she would have already been in court at this point. Oh my goodness. Oh, and they have a new judge too, but
I've been here for 4 years and I'm tired of being here and I'm tired of going through all of these attorneys, which are not my fault.
Sarah Boone is getting another.
And then what did she say at the end? This poor woman. Does she know what she's in for? I think she does. Maybe a female will be different with her, you know? Maybe.
But when 100 days have passed and I haven't heard or said or done anything other than try to figure out where you are because your phone doesn't work, I'm not a bad person because of that.
Why does she always say, I'm not a bad person? Why does she always say that? I'm not a bad person. Oh my goodness. All right. This just blows my mind. Oh, and by the way, if you came here for legal opinions on this, I don't have any because I'm not a lawyer. I don't know anything about legal stuff. I just like to talk about crazy. I know crazy. Crazy, I know. And this chick is batshit crazy. No law for that. Otherwise, we would have no legislative branch of government. Are you talking about, what are you talking about, Barbara? The changing lawyers? Girl, she did make homemade candles. Did I not send you hey, Barbara, no one got a notification because I went live on the spur of the moment. And I did it a little different than I normally do it. I tried to stay I put it on unlisted and then I put it back on public. So I screwed myself up that way. Thank you all for coming in and listening to me complain about this. I don't know. I don't think it's an agenda. You guys give these people way too much credit. This woman is not, I honestly don't think she's trying to be slick. I think she's just freaking insane. And I think they do need to have somebody test her. She's OCD having, label making owner. And if she wasn't an alcoholic, she would have been part of that PTA or whatever. I wonder if she ever let her kid breed. I'd listen to Miss Carrie read the telephone book. Oh, Cass, I love you, but honey, that ain't right. She's peanuts. She's nuts. I'm perplexed. Let's listen to this one more time. I'm perplexed. We'll go back to the front. I'm going to make a loop of that, y'all. We're going to have a Psycho Sarah loop to watch.
Well, the woman you see here, Sarah Boone, faces charges after investigators say she murdered her boyfriend by leaving him zipped up in a suitcase. Police arrested her 4 years ago, and she was in court this morning to ask that her case quickly move forward. West 2's Bob Hazen was in the courtroom where the judge gave Boone another lawyer.
Sarah Boone's been through a lot of lawyers. In fact, this is now her 7th attorney, her last one saying that she wanted him to do things that he wouldn't do.
I've been here for 4 years and I'm tired of being here and I'm tired of going through all of these attorneys, which are not my fault.
Sarah Boone is getting another chance to find the right lawyer to defend her in this bizarre case. In 2020, investigators say she left her boyfriend, Jorge Torrez Jr., zipped up in a suitcase after a game of hide and seek and recorded him begging for help.
Sarah, I can't breathe, babe.
Poor guy.
Seriously.
Yeah, that's when you do and you choke me.
Boone allegedly went to bed and then found him dead in the suitcase the next day. Since then, Boone's trial has been delayed repeatedly as she gets into conflicts with her lawyers, something the judge in her case noted.
Seemingly all of your relationships with counsel have deteriorated.
Boone often writes letters to the judges complaining about her lawyers. Attorney Winston Hobson was appointed back in September, but asked the judge to let him withdraw, saying they're at loggerheads and she makes difficult demands.
I would say Ms. Boone has some ideas about what should be done, should not be done. I don't agree with those. Some things she wants done, I won't do.
But when 100 days have passed and I haven't heard or said or done anything other than try to figure out where you are because your phone doesn't work, I'm not a bad person because of that.
The judge gave Boone a new lawyer, but did not push back the trial, which is currently set to start in May. At the Orange County Courthouse, Bob Hazen, West 2 News.
Hang on. Shut up, Carrie. Okay. I was pulling up my old channel. Let me see. So they didn't, that's just not fair to that attorney. That's like handing them a pile of shit on a plate. You know what I mean? Like, here you go. You get Sarah and this, and you've only got this much time to get it all done. Jeez, my knees. Okay, a lot happened on Friday, and I am just now getting to it, so I apologize. We'll start with this first video. Suitcase Sarah was back in court on Friday morning. Her attorney is saying, I need more time. So basically, the new attorney came in and said, I've hired an expert, got that started, but she's going to have to do an evaluation. And once she does an evaluation, that's where we're going to see where we're going to go towards, I guess their strategy in trial. So the judge moved everything back to June 7th for a status hearing to then try to set a date for when they can actually have the trial start. Can you believe? I guess I can believe it, but gosh, y'all, that's 2 months away. 2 more months. This woman, how long she been in jail now? And see, here's what I'm worried about. I'm worried about this evaluation coming back and Sarah being in an uproar about it and getting all upset about the strategy that her new attorney, her 7th or 8th, I don't remember which one it is. I think it's her 8th, wants to go towards, and her not agreeing with that and it becoming a problem again. And then where are we? Are we back to square one? Has she not learned her lesson? I guess she feels like no matter what she does, she's screwed. So I'm going to be sitting in jail fighting this in court, or I'm going to be sitting in jail with sentenced. So, who cares? Or is Sarah even thinking that far? We don't know. I kind of feel like there's not a whole lot of, the lights are a little dim. The lights are a little dim in the stadium. So y'all stay tuned. I'll stay on top of this and we'll touch back again on June 7th to see what happens. Suitcase Sarah met with the judge today. So please come on in. Give everybody a few minutes to come in because, like I said, this came up like this was just on the spur of the moment. So, hey. I knew it. Lenny said, I knew it. Hey, Sean. Okay. So here's what's happening. Somehow, I don't know, they met in private. Did they meet? I don't know. Yes, Jerry Wayne, for reals. It's happening. Daryl Brooks appeal delayed again. Yep, they pushed. For those of you who are interested, today was the deadline for Daryl Brooks' appeal, and it has been pushed. Well, they just extended the deadline. No big deal. All right. So, Suitcase Sarah. Apparently, they met with the judge. So let's go in here and review all this stuff. I'm so excited. I'm shaking. Oh, my word. Oh, my word. All right. So here we have the docket. And according to the docket, see, when I went in here earlier, when I kept going in here, you'd see her, first they added the 58-page letter. And then they still had 9/24 hearing management, case management. And then they had October 7th hearing. And then just somewhere in between, sometime today, they added this in. So they took her motion to withdraw, which we're going to read that, the 16 pages. The comments, it says in the comments, the court addressed Attorney Cashman's motion to withdraw. Free Patricia. Patricia is free. Hallelujah. Patricia, girl, go on with your life. She's going to have a good weekend. She's going to have such a good weekend. Bless her heart. Okay. The defendant was placed under oath. The court read on the record its orders dated 6/24 of 2024 as it relates to the motion to withdraw the defendant in open court. The defendant gave a statement and asked questions of the court of his order. The defendant was provided a copy of the court's order hand-delivered, Sarah, we know how you enjoy that, on 6/28 of 2024 by Officer Jones and Thomas. Okay. It says above that, the court made findings that the defendant has forfeited the right to counsel. The motion to withdraw was granted. As a condition of Attorney Cashman's withdrawal, poor Patricia, she shall provide the court an order for cost to obtain transcripts of depositions for the 2 witnesses she deposed. Upon completion of the transcription of the depositions transcripts shall be sent directly to the defendant at the Orange County Jail. Attorney Cashman shall file a notice with the court reflecting that the depositions transcripts were provided to the defendant. All previously set dates remain. So, Sarah, you got 4 months till 9/24. That's 3 months. All pretrial motions must be filed no later than the close of business on Monday, July 22nd. So if she wants to do anything or needs to do anything, she's got to do it by, she's got a month. She's got less than 30 days. Serves her right. The court ordered Attorney Cashman to provide the 2 boxes of discovery with the clerk marked as identification A and B. Oh, I'm feeling a fort box coming on. Anybody else feeling a fort box? Fort box. Or should I say box fort? I'm having withdrawals. or flashbacks. I'm having acid flashbacks. Okay, the court will reach out to the jail to inquire how to deliver to the defendant. Let's look at this letter. Well, it's not a letter. It's the motion to withdraw. Hang on, I gotta open my Diet Coke. This is serious. I gotta drink a little bit. It's just Diet Coke though. Okay, it says the cause came before the court on June 28th of 2024 on defense counsel Patricia A. Cashman's Esquire motion to withdraw as counsel filed June 11th of 2024. The court having reviewed the motion, having reviewed the court file and Sarah's letters, having reviewed the audio transcripts from various hearings, having considered the position offered by counsel Patricia A. Cashman Esquire. Oh, the judge said, Patricia, will you take me with you? Having considered the testimony offered by the defendant, Sarah Boone, and having considered the positions offered by counsel for state, hereby finds that on March 23rd of 2020, the charges were by way of information, the defendant was charged with second-degree murder. Procedural history. On February 26th of 2020, the Office of the Public Defender, 9th Judicial Circuit in and for Orange County, Florida, was appointed to represent the defendant as a public defender. And I think it's so cute how in the motion they put attorney number 1. Oh, Lord. I'm not going to be able to get through this. Okay. On March 9th of 2020, the public defender moved to withdraw due to the defendant retaining private counsel, to wit, Mauricio Padilla, Esquire, and the Padilla Law Group, aka attorney number 2. On March 11th of 2020, that certain order allowing withdrawal was entered which withdrew the public defender from further representation of the defendant. On April 18th of 2022, Padilla moved to withdraw due to irreconcilable differences. Why couldn't I get that out? I'm so sorry. Arising between undersigned and the defendant that have made it impossible, the word when referring to Sarah, for undersigned to effectively represent said client or his client. As always, it is difficult to convey all particulars to the court and at the same time maintain all duties to the client. The motion was served upon the defendant and the defendant confirmed receipt. I did read somewhere where one of the attorneys said, you really have to be careful when you do this. You can't say anything bad about Sarah. You're not supposed to, but oh my gosh. So there's a letter dated April 20 of 2022 and filed on April 26 of 2022. On April 29th of 2022, a hearing was held on Padilla's motion to withdraw. At the time of the hearing, Padilla had been representing defendant for 2 years. Defendant was present for the hearing and was sworn. The court advised Padilla that the court had received a letter from the defendant, which seemingly objected to Padilla's withdrawal. The court advised Padilla that the options were to not proceed on Padilla's motion to withdraw or provide the court more about the irreconcilable differences. Padilla requested an opportunity to amend the motion to address the irreconcilable differences. The court reserved ruling on Padilla's motion to withdraw. They gave Padilla until May 3rd of 2022 to prepare and file, and an amended motion with a hearing to be heard in the week of May 9th of 2022. The state advised of Padilla's diligence in preparation, and the court commended Padilla's work. The defendant testified to a lack of trust between herself and Padilla. On May 4th of 2022, Padilla filed an amendment motion to withdraw, which supplemented the original grounds. Let's see. Do I need to read all this? Undersigned's relationship. Yeah, we need to read this. Okay. Undersigned's relationship with defendant has become adversarial. The aforementioned adversarial relationship has interfered with undersigned counsel's ability to effectively represent his client, especially preparing for trial. Undersigned appreciates the court providing him the opportunity to amend his previously filed motion to withdraw. However, after a 2-minute consideration, we've said no, we're going forward. Further researching the issue, undersigned is still under the belief that the specifics of the adversarial relationship may disclose information that may prejudice his client, and as such will stand mute on the specifics. Bless his heart. That is a man of God right there, y'all. That is a man of God. Are you guys with me? Are y'all with me? Yes, the headline is, I'm not kidding. I am not kidding. This is real, you guys. Yeah, she's going to be called attorney. Kona's mom said she's going to be called attorney numero uno. She'll be her 9th attorney. Okay, let's keep reading this because this is going to get good because this is giving us the details of what went on in the past, which means I'm going to have to do a whole parody on this one. On May 6th of 2022, Padilla filed a second amended motion to withdraw, which further supplemented the original grounds. Undersigned relationship with the defendant has deteriorated to a point where undersigned counsel can no longer give effective aid in the fair representation of Ms. Boone's defense. This motion is in compliance with the Florida Judge Administration, blah, 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 blah. Okay, Florida Bar are present, and whether the attorney-client relationship has deteriorated to a point where counsel can no longer give effective and aid in the fair presentation of a defense. All right, so then on May 10th of 2022, a hearing was held on Padilla's second amended motion to withdraw. The defendant was present for the hearing and was sworn. Padilla advised the court that he had no other choice to file the motion due to ethical concerns. Defendant confirmed that she wanted to terminate Padilla as her attorney. The state expressed concerns of a strategy to allow defense attorney The state expressed concern of a strategy to allow defense attorney after attorney to represent defendant. The court advised the defendant of the state's concern regarding a strategy of defendant being unhappy with every attorney and advised defendant about the dangers of self-representation. The court appointed another public defender, aka attorney number 3. I just love their number. On June 6th of 2022, the public defender moved to withdraw due to a conflict. On June 7th, 2022, that certain order allowing public defender withdrawal was entered, which withdrew the public defender from further representation of the defendant and appointed the Office of Criminal Conflict and Civil Regional Counsel. So wait a minute. They didn't even go into a whole lot of detail about that. That guy came out like he was like anonymous. He was wearing one of those anonymous masks when he went in and represented her. On June 10th of 2022, RCC moved to withdraw due to a conflict. Oh, wait. So the Office of Criminal Conflict and Civil Regional Counsel, aka attorney number 4, came in. And then on June 10th of 2022, RCC moved to withdraw due to a conflict. On June 22nd, 2022, that certain order allowing the Offices of Criminal Conflict and Civil Regional Counsel withdrawal was entered, which withdrew the RCC from further representation of the defendant and appointed Mark Consalo. Y'all, I'm reading far away. My computer screen, it's really far away, so I apologize. AKA attorney number 5. On July 8th of 2022, Consalo moved to withdraw due to a conflict. So he lasted 2 weeks, less than 2 weeks. On July 11th of 2022, that certain withdrawal order was entered, which withdrew Consalo from further representation of the defendant and appointed Frank J. Bankowitz, which was AKA attorney number 6. And we're familiar with Bankowitz because he's the one that, that's when they started showing her in court more. They started showing these hearings. On July 12th, which if you guys aren't familiar with the case, go back. I got a whole playlist on it. On July 12th of 2022, Bankowitz in open court requested a continuance due to his recent appointment and same was granted. Thereafter, the court set a pretrial conference for October 25th of 2022 at 9 a.m. and trial during the trial period beginning on November 7th of 2022. 2 years. On October of 25th of 2022, the court held the pretrial conference and addressed the court's understanding that a continuance was being sought as the court's judicial assistant was to reach out to the parties to confirm if a continuance was being sought. Now, if you guys don't remember, that he really truly needed a continuance because Bankowitz was trying to get the money through, what do they call that? It might be written here somewhere, where they approved the money for them to get an appointed psychiatrist or whatever, right? And it has to be a certain fee. And he was having a hard time finding anybody that even wanted to work with her. On October 27th of 2022, Bankowitz filed defendant's motion to continue. On October 28th of 2022, the court entered that certain amended order on defendant's stipulated motion to continuance, which set a pretrial conference for January the 17th of 2023 at 9 a.m. and trial during the trial period beginning on January 30th of 2023. On November 22nd of 2022, the court set a status hearing on December 20th of 2022 at 10:45 a.m. On December 19th of 2022, Bankowitz moved to withdraw due to the I can't look at the word, I just got to say it, due to irreconcilable differences which have arisen between the undersigned, his client, and his family. The undersigned will be unable to effectively and properly continue representing the defendant herein. And of course, we're all familiar with her letters because that's when the letters really got hot. On December 20th of 2022, the status hearing was held, and Bankowitz did not appear due to a car accident, and the court reset the status hearing on December 22nd. Okay, fair enough. He had a car accident. But she was still mad. Remember how mad she got over that? She was a fuming. Okay. On December 22nd, 2022, the reset status hearing was held, and Bankowitz appeared virtually, and due to technology issues, Bankowitz was unable to hear the court. The court reset the status hearing for December 27th of 2022. So on December 27th of 2022, a hearing was held on Bankowitz's motion to withdraw, and the defendant was present for the hearing and was sworn. The court advised defendant that the court had received letters from the defendant. A letter dated October 3rd of 2022 and filed on October 7th of 2022, a letter dated November 3rd of 2022 and filed on November 7th of 2022, and another letter dated December 5th, also filed on December 14th of 2022. The court conducted a Nelson hearing, and the defendant was not seeking to remove Bankowitz. Bankowitz advised the court of the thousands of pages in discovery that he had reviewed and organized, and his contact and potential use of and collaboration with expert witnesses, including experts that Padilla, attorney number 2, had utilized. Bankowitz advised the court of the defendant's attempt to call Bankowitz at a rate of 5 to 10 times per day. That's all. Can you imagine if she actually had access to a phone more than just a couple of times a day? I mean, she is in, she's in jail. So I'm just saying it would have been a lot more than that. Bankowitz further advised of his efforts to balance the demands of other clients with the defendant's expectations for communications. In response, the defendant reposted that Bankowitz's representations were untruths. She raised that Bankowitz's prior public reprimands for lack of communication. She alleged Bankowitz's action in this case rose to a similar level and then sought to remove Bankowitz. I think it's funny how every time these people want out first, she turns around and says, "No, you can't leave. I'm going to fire you." The court pointed out defendants' inconsistent statements within minutes of them being made and addressed concerns over the defendant's motivations, especially when there is something the defendant disagreed with. The court specifically advised the defendant that she is not entitled to an endless line of court-appointed lawyers until you find the one that you personally prefer. The court also explained the circumstances where defendant could represent herself. Ultimately, the defendant did not request to remove Bankowitz. The court denied Bankowitz's motion to withdraw and left him there hanging and directed him to have a conference with the defendant prior to the pretrial conference previously set for January 17th of 2023. Bless his heart. The case was continued several times due to Bankowitz's attempt to retain an expert. That was it, through the JAC, because the JAC is the one that's going to pay for it. So during this time period, the court had received several letters from the defendant, a letter dated January 10th of 2023. I'm not going to tell you when they were filed. A letter dated March 23rd. A letter dated April 6th, 2023. A letter dated May 15th, 2023. A letter dated June 29th, 2023. And a letter dated August 2nd of 2023. On August 22nd of 2023, Bankowitz again moved to withdraw due to irreconcilable differences arising between undersigned and the defendant that have made it impossible for the undersigned to effectively represent his client. As always, it is difficult to convey all particulars to the court and at the same time maintain all duties to the client. Can they ever say anything? I guess they can't. I guess they can't ever say anything against her. The defendant will not be satisfied with any attorneys unless said attorney does not have a caseload and can dedicate his or her time solely to Mrs. Boone's case. The best possible avenue is to have the defendant represent herself, as no attorney can satisfy her. On September the 8th of 2023, a hearing was held on Banquet's motion to withdraw, and the defendant was present for the hearing and was sworn. Banquet addressed defendant's derogatory statements, calling him a dud and a buffoon, and berating behavior. The court advised the defendant that the court had received letters from the defendant as well. One was dated August 26th, and another letter was dated August 30th. And yeah, that was all at that point. And then after the court's colloquy of defendant and her acquiescence is how do I say that? To Banquet's withdrawal, the court granted Banquet's motion to withdraw and appointed Winston Hobson, bless his heart, attorney number 7. And by the way, if anybody's making fun of the way I'm reading, look. Just don't, okay? Thereafter, the court set a status conference for October 30th of 2023 at 10 a.m. and set a pretrial conference on November 28th of 2023 at 9 a.m. After setting these dates, the court pointed out the deterioration of working relationship between defendant and Banquet. The court further cautioned that if this becomes a problem on another court-appointed attorney, I'm going to look more closely at what the alleged disputes are. The court further advised that there are certain decisions the attorney gets to make and certain decisions a defendant gets to make. Go to trial and or testify. The court cautioned as to the defendant's unrealistic expectations regarding court-appointed counsel and reminded the defendant of her right to retain private counsel. On October 30th of 2023, the status conference was held, and Hobson advised as to conversations with defendant and setting a status in January of 2024. Thereafter, the court set a pretrial conference status as to the readiness for the trial on January 16th of 2024. So on January 12th, Hobson filed that certain motion to continue, waiver of presence, and requested a 3-docket continuance. On January 16th, the court addressed Hobson's motion to continue and granted same, set a pretrial conference for May the 3rd of 2024, which a trial would begin on May 13th. On February 1st, Hobson moved to withdraw due to irreconcilable differences, including but not limited to ethical considerations. On February 9th of 2024, a hearing was held on Hobson's motion to withdraw. Hobson addressed a number of issues as for the basis for the withdrawing, including disagreements on legal strategy, on what can and cannot be done, a lack of resources, and defendant's demands make her difficult to work with, including defendant taking non-viable legal positions and being unreasonable. As to a key substantive defense, Jesus, I know I sound like a moron. I can't read. Hobson advised that the retained and undisclosed expert is not keeping with what the defendant has in mind. The court advised the defendant that the court had received a letter from the defendant, a letter dated January 19th of 2024. The court outlined the overriding claims for withdrawal by Padilla, Banquet, and Hobson, adversarial relationships, lack of satisfaction, and inability to meet the defendant's desires. The court found that all the defendant's relationships with all court-appointed attorney counsels have deteriorated such that the defendant and the court-appointed counsel cannot work together. The court advised the defendant that although the defendant has a right to court-appointed counsel, that right is not unlimited. Why does that sound so familiar, Brooksaholics? It is not unfettered. The court twice advised the defendant that the defendant may not be provided another court-appointed attorney and that the defendant would have to represent herself if circumstances similar to Hobson's motion to withdraw occur. The court further advised the defendant about the dangers of self-representation due to the defendant's lack of legal training and knowledge, even though she does excel at everything she does. That's not really in there. I just said that. The defendant never stated that she did not understand that she may not be provided another court-appointed attorney. The court granted Hobson's motion to withdraw and appointed Patricia A. Cashman, aka Attorney Number 8. The court is aware of Cashman's extensive experience representing criminal defendants as both an assistant public defender and in private practice, including representing defendants accused of murder, and is widely known to be able to and willing to deal with and manage difficult clients. So you know what? I wonder if the judge seeked her out specifically. It kind of sounds like it, right? The court set a status hearing for April 12th of 2024. She probably said, can you imagine it? The judge is like, look, I really need you to represent this defendant because I don't know what else to do. Nobody will stand up. And then she's like, okay, but one letter. She writes one letter and I'm out. You guys, I'm saying all this. I have no idea how it really works. Okay, so I'm probably wrong. On April the 12th of 2024, the status hearing was held, and Cashman advised as to the depositions that had been set, the hiring of an expert, and request for a future status date to address a trial date. The court set a status hearing for June 7th. Okay, now this is where most recently June 7th happened. Status hearing was held. Cashman addressed her dates of availability for trial. The defendant was present for the hearing, of course, as she always was. Thereafter, the defendant advised the court to walking out of at multiple meetings with Cashman, which was confirmed by Cashman utilizing a pretend judge to oversee defendant and Cashman, launching multiple attacks on Cashman's professionalism and providing the court with letters dated June 4th of 2024 and June 7th, 2024, and both of which were filed on June 21st of 2024. Cashman advised to her efforts and time spent on the case so far, 20 hours. Cashman advised disagreements on legal strategy, including the defendants attaching importance to issues that may not be legally important. So the defendant accused Cashman of lies and half-truths. And on June 11th of 2024, Cashman moved to withdraw under Florida rule, blah, blah, blah. Hang on, I gotta drink something. Excuse me. Basically, substantial risk that the representation of one or more clients will be material limited by the lawyer's responsibilities to another client, and irreconcilable differences, including but not limited to ethical considerations, have risen, such as counsel can no longer provide representation. All right, KK. On June 28, 2024, a hearing was held on Cashman's motion. This was today, guys. Cashman relied on Florida rule, blah, 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 as the basis for the withdrawal. Didn't say what time they met, though. At no time has defendant refused to accept the services of any of her 7 appointed attorneys. Okay. Both the United States and the Florida Constitutions guarantee an indigent criminal defendant the right to assistance of appointed counsel. The counsel clause of the Florida Constitution under Article 1, Section 16 recognizes the right to counsel as well as self-representation in all criminal prosecutions. A defendant in a criminal case can forfeit a right to court-appointed counsel. A forfeit is an extreme measure that flows from the defendant's abuse of or manipulation of the right to counsel and results in the defendant being required to represent himself even though he has not waived counsel and may still want legal representation. So they're forcing her to represent herself? Forfeiture is a judicial response that adapts the course of the legal proceedings to the defendant's choice to engage in misconduct that undermines the legitimate exercise of the right to counsel. They call him Miss Sarah out. As set forth above, defendants, what is that word? Recalcitration? Whatever. Her constant berating of all the attorneys we've assigned to her who were not conflicted out. Padilla, Bankowitz, Hobson, Cashman. Antagonism, hostility, and attacks on the professionalism of Padilla, notably over a year after the fact of Bankowitz and of Cashman, and personal attacks on Padilla, Bankowitz, and Cashman. Each of these attorneys were required to withdraw. It has become apparent to the court that the defendant will not permit herself to be represented by anyone. Additionally, The withdrawal of 8 different attorneys, 7 of which were court appointed, leads to a determination that the defendant has forfeited her right to counsel. Under Florida law, the facts at bar amount to a binding forfeiture of the right to counsel. As the court finds defendant has forfeited the right to court-appointed counsel, under Florida law, there is no obligation to conduct a Faretta hearing, or to otherwise warn a defendant of the dangers of proceeding pro se. Oh God, here we go again. Pro se. The court can find a waiver by conduct to the right of counsel. Waiver of conduct requires that a defendant be warned about the consequences of his conduct, including the risk of proceeding pro se. On February 9th of 2024, the defendant was twice advised that another court-appointed attorney may not be provided. On May 10th of 2022, the defendant was advised about the dangers of self-representation. On February 9th of 2024, the defendant was advised about the dangers of self-representation. No, I didn't just read that same thing twice. It was a separate day. And then on February 9th of 2024, the instant case had been continued 16 times. 16 times. As for June 26th of 2024, this case has been pending 4 years, 3 months, and 5 days from the date of the filing of the information on March 23rd of 2020. Yeah, that, and you know what, guys? It's like not lost on all this is the family's waiting for their day in court. You know, the family, the victims in the case. Actions speak louder than words. Although the defendant's words seemingly reveal a desire to go to trial, however, as set forth herein, her actions and inability to work with court-appointed counsel are repeated over and over, allowing the defendant to her 8th court-appointed attorney, her 9th overall, will only serve to delay the case further and encourage the defendant to persist in efforts to prevent the resolution of the case on its merits. Remember, she wanted a successful outcome, though, y'all. Remember, the concept of which was brought defendant to her attention on May 10th of 2022. Defendant complains that Banquets and Hobson, the 2 court-appointed attorneys, failed to meet and communicate, and when defendant is provided court-appointed counsel who will meet and communicate, Cashman, the ways and means of meeting and communicating are unacceptable to her. Excuse me. All right. We're almost done. Under Florida law, the facts at bar amount to a binding waiver of the right to counsel. So Cashman's motion to withdraw was June 11th. This is orders and adjudication. Okay, so as a condition of Cashman's withdrawal, Cashman shall provide the court. I've already read this to y'all, but I'll read it again. An order for the cost to obtain transcripts of depositions for the 2 witnesses Cashman deposed. Upon completion of the transcription of the depositions transcripts shall be sent directly to the defendant, Sarah Boone, by Cashman at the Orange County Jail. Thereafter, Cashman shall file a notice with the court reflecting that the deposition transcripts were provided to the defendant, Sarah Boone, and such notice shall be included in the date sent and the address of the defendant, Sarah Boone. Then Cashman will go out and drink heavily. It doesn't say that, but that's what I was kind of thinking. Okay. The defendant, Sarah Boone, has forfeited her right to court-appointed counsel. Alternatively, defendant Sarah Boone has, through waived by her conduct, her right to court-appointed counsel. The trial management conference shall remain specifically set for Tuesday, September 24th at 1:30 p.m. And man, is that going to be a circus. Oh my goodness. You guys, just go ahead and mark your calendars now because it's going to be on this channel and it's going to live. Grab the popcorn. This case shall remain specifically set for trial for the 2-week trial period beginning Monday, October the 7th at 2024 and will not be continued for any reason except by extraordinary good cause, and such extraordinarily good cause shall not include retention of counsel by the defendant. So even if she goes out and gets another attorney, they're not going to give him any more time than it's it. We're done. I bet she goes out and gets another attorney. She's going to call Brian, her ex, and beg him for money. Any and all pretrial motions in this case must be filed no later than the close of business day on Monday, July the 22nd, which you guys, that's less than 30 days. Less than 30 days. Sincerely, Michael S. Crescent. It didn't say sincerely. And there's no emoji heart on there. There's no cat emojis at the bottom of his document, as was Sarah's. So I guess she had to sign off on all this. So there you go, kids. Well, she has fans in Korea. Are y'all talking about her fans in Korea? Yeah. She's got one in Korea that has been writing her, apparently. They're big buds. Maybe they'll pay for her attorney. Is that what Love My Vet Off Grid said? So of course, she's going to automatically, because she has already, she's been compared to Daryl Brooks. So it's going to get even worse now. Oh, I still had that banner up. My bad. Take that down. It's going to get even worse. So while we're here, there's something that I did want to bring to y'all's attention that I had, because I feel like it's just needed for right now.
I've been here for 4 years and I'm tired of being here and I'm tired of going through all of these attorneys, which are not my fault. But when 100 days have passed and I haven't heard or said or done anything other than try to figure out where you are because your phone doesn't work, I'm not a bad person because of that. I'm not a bad person because of that. Not my fault. 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 Not my fault.
Oh, Sarah. You guys, I'm sorry. I don't mean to be disrespectful to the families. They've lost someone in this, but this is unbelievable. Thank God for court TV. Thank God that we can now watch trials on YouTube, because if we couldn't watch this, I don't know. But I guarantee you, everybody that watched Brooks's trial, they're going to be tuning in for this. Now, let's just play this down a little bit. Let's think ahead. See if we can kind of, thank you so much, Patty. I appreciate that. Let's kind of play the scenario out. How do we think she's going to act? I think she's going to try to, if she doesn't hire an attorney, because there's still time for her to hire an attorney as long as somebody says, yeah, we'll go ahead and take it. But really, who would take her case? Who would take her case? And I mean, she doesn't have a lot of money, but I hope Brian doesn't do that. I think Brian wants her gone. You guys, we're going to listen to Brian's thing here in a minute. I've got that ready to go. So we're going to go ahead and listen to that. But I see her sitting down and going, okay, well, I excel at everything I do. And I have all this paperwork sitting out, right? And I'm like trying to put this all up there so that we can all see what's going on. And I don't like, excuse me, I don't like the way the prosecution just looked at me. I don't appreciate that. I don't like her tone. Could she please be nicer to me? Or he, is it a he? Could he please be nicer to me? Now, that's somebody else who's lost in all this. The prosecution. The prosecution has been sitting with this thing for the same guy has been waiting all this time. All this time. Oh, thank you, Elaine. That's very nice of you. Sarah should spend her time suing her hairstylist rather than, girl, don't get me started on that hairstyle. Don't even get me started. She needs to go back to her other haircut. You know, I mean, she is in jail. She chose that hairstyle though. You know, that person that cut that hairstyle knew what they were doing. That's not an easy cut. So I just kind of see her going through and just kind of, we're going to see the same stuff over and over again. It's going to be repetitive. The stuff that she said it's going to be all very repetitive. She's going to make mistake after mistake after mistake. What could happen here, y'all? What could possibly happen? Now, here's a thought. She could hire someone to be an assistant counsel for her, like Brooks could have done, right? So let's say she says, well, I'm going to do everything myself because I excel at everything I do. And, I know what I'm doing. I'm a very intelligent person and it wasn't my fault. So I'm going to do this. And I need you just to sit there and kind of keep me in line with the like law, like just that little thing about, just the law, just that part. Because I pretty much get up there and say what I want to say, right? Mistrial. Steven says mistrial. No, but here's the thing. Ain't no way, excuse me, I just said ain't, but there's no way, you guys, that they're going to give her a mistrial. There's just no way. She's not going to get off on this because she's been difficult. And I don't know I honestly don't think she's that intelligent. I don't think that's where she's going with this. She truly believes in everything she's saying to everybody. She truly believes that she is not the common denominator in any of these attorneys leaving. This is mind-blowing. This is mind-blowing. Oh, yeah. Sarah's in Florida. Brooks was in, is that what you're talking about, Wisconsin? So when is the trial going to begin, Kathy asked. Well, Kathy, according to these documents, we're going to have a hearing on September the 24th, and trial will start on October 7th. And they're expecting it to be a 2-week trial. But I think as a judge, if I'm sitting here going, okay, now she's going to represent herself, maybe we need to give her 3 weeks. Maybe we need to extend this to 3 weeks, 4 weeks. You know what I'm saying? Like, do they really, because you know there's going to be too many things that they're going to have to call her out on. They're going to have to correct her. She's going to argue it. He's going to say no. She's keep doing it. I mean, she's not going to be as bad as Brooks. I do believe that Sarah has a smidgen more conscience than Brooks did. It's just a smidgen. October 2043, David. No, it's actually this year. How will she hire her expert witness? Well, isn't that still through the JAC then? She still gets some money for that? I wonder. She does say, CD man, that she is a straight A. She was a straight A student. Yes. But she never got an A in common sense. Sarah does not know how to read a room. No, she does not. She'll be her own expert witness. You are so right, Kathy, because she knows it all and we know nothing.
I'm not a bad person because of that. Not my fault. Not my fault. Not my fault. I'm not a bad person because of that.
Well, hello, everybody. How are we? I'm coming on a little bit early because I want to test something. When I found this video, God, it's crazy. I wasn't even going to be in here this morning or this afternoon. I was supposed to be somewhere else, and I ended up getting stuck working on my other channel. And in doing that, I decided to check my Google stuff, and an alert popped up for Sarah. And I was like, holy crap, how did I miss this? Well, it wasn't on the docket. Apparently she's really pissed about that too. So hang on. I'm not going to play all of it just yet because I did set the stream for 1:35. So we got to give everybody a few minutes to come in, but so we're about 3 minutes ahead of time. That's really not that bad. Suitcase Sarah Boone was back in the courtroom this morning. Let's see what happened. All right, let's see. Okay, it's really low. So you guys turn up your volume as loud as you can after I finish talking, because I know my voice will blow you out of the water. But I literally turned up the volume as loud as I could on this. Oh, and by the way, I forgot to cut out on I'm hoping they pauses. Fix her mic. It sounds like her mic's really super low.
Dave Cacciatore on behalf of the Dave Cacciatore on behalf of the state.
Ms. Boone, good morning. Could you please raise your right hand so Madam Clerk can swear you in?
Yes.
Ma'am, good morning. Can you state your name and date of birth for the record for me?
Sarah Boone, 10/10/77.
We also have a representative from Prison Break Investigation. Sir, if you could come forward, please. If you could, sir, raise your right hand. Madam Clerk's going to go ahead and swear you in.
Do you swear or affirm that the testimony you give shall be the truth, the whole truth, and nothing but the truth, so help you God?
All right, sir, good morning. Could you state your name for the record?
Billy Lane.
And Mr. Lane, what's your affiliation with Prison Break Investigations?
I'm the owner and chief investigator.
Okay, very good. The reason the court had this hearing this morning is the court has found that Ms. Boone has forfeited her right to counsel and waived her right to counsel alternatively by virtue of her conduct in this case. As such, Ms. Boone is currently representing herself. The court has been working diligently to provide you the discovery. I received your letter, ma'am, and I have reviewed it. We have not forgotten about you. It's just taken some time in order to coordinate the appropriate processes with the jail. In conversations with the jail, a laptop has been secured and will be issued to you after USB drives are provided with all the discovery. Upon the jail's receipt of those items, the following provisions will be adhered to. The laptop, charging cable, and USB devices will be kept in the FDC main control room when not in use. At no time will the charging cord be placed in the housing unit. Upon the return of the laptop to the FDC main control, the laptop will be placed on the charging cable to ensure it is available for the next day's usage. The laptop and USB device is to be accounted for with the control room inventory. The control room DSP or CO will make logbook entries for the issuing and returning the USB device and laptop. The dorm officer will make logbook entries for the receiving and returning of these items to the applicable movement officer. A notebook entry will be completed in IMS for every issuance of the laptop and USB device to inmate Boone. The laptop and USB device will be available daily to you, Ms. Boone, between 0800 and 1600 hours. A notebook entry will be completed in IMS for every issuance of the laptop and USB device to yourself, Ms. Boone. The discovery was provided at the court previously and is in the two bankers boxes that are in front of the court to your left, Mr.
Okay, I just gotta say something. Oh God. Wait. You guys know what this means. Now she's gonna be typing her letters to the judge. No more pens. Oh, her letters might become more frequent now. Who knows? Where were we?
Laptop and USB device is to be accounted for with the control room inventory. The control room
This might be better.
DST or CO will make logbook entries for the issuing and returning the USB device and laptop. The dorm officer will make logbook entries for the receiving and returning of these items to the applicable movement officer. A notebook entry will be completed in IMS for every issuance of the laptop and USB device to inmate Boone. The laptop and USB device will be available daily to you, Ms. Boone, between 0800 and 1600 hours. A notebook entry will be completed in IMS for every issuance of the laptop and USB device to yourself, Ms. Boone. The discovery was provided at the court previously and is in the two bankers boxes that are in front of the court to your left, Mr.
Oh God. Wait. You guys know what this means. Now she's gonna be typing her letters to the judge. No more pens. Oh, her letters might become more frequent now. Who knows?
Lane. I'm going to order you, sir, to take possession and custody of that discovery that was provided to the court previously on June 28, 2024. You, through Prison Break Investigations, shall copy all of the discovery onto as many USB jump drives as necessary.
So she's not gonna have
The Judicial
Wi-Fi.
Administration Commission for the state of Florida shall be responsible for the fees and costs due to Prison Break Investigations for copying all of the discovery onto as many USB jump drives as necessary. You will appear for a hearing with the court on August 1st, 2024 at 8:45 in courtroom 12A of the Orange County Courthouse with the discovery and all USB jump drives containing the discovery. A representative from the Orange County Jail shall also appear for that hearing as well. At that point in time, Prison Break Investigations shall hand deliver all USB jump drives containing the discovery to the representative from the Orange County Jail in order to be placed onto the laptop that is currently secured and to be issued to the defendant for all trial and court preparation. Do you have any questions for me, sir?
I have a conflict for August 1st, Your Honor. I'm
Okay.
going to be out of state from Tuesday until Friday of next week, which I believe is the conference office first for my son's wedding.
Okay, well, congratulations. When do you return from your son's wedding, sir?
I will be back late Friday evening, so I'll be available the following week.
Okay, will you be able to complete that task by that time?
Yes, sir. I'll do my best.
Okay, sir, we will see you on give me a second, I want to make sure I get the date right. Monday, August 5 at 8:45. Okay, you'll be given a copy of the order that I just read from. Ms. Boone, you'll also be given a copy of the order. Do you have any questions for me?
I am thoroughly confused. Was a notice ever cut online for this or mailed to anyone? I don't even know why Mr. Lane is here. I don't know why I'm here.
Well, ma'am, you are now representing yourself, and previously you had requested to appear at every hearing that was held. As you are now representing yourself, the court cannot have any hearings regarding your case without you being here. I put on the record and explained to you the process that the court has had with communications with the jail. I'm not allowed to look at any of that. I'm not allowed to copy any of that. So in speaking with the jail and understanding that you still have a private investigator that was provided to you through the state that's being compensated by the state, you're still allowed to utilize his services. The protections of the attorney-client privilege are still applicable to him. So he's able to review any of these documents, ensure that they are safely copied without violating any terms of the privileges. Those will then be placed on multiple USB drives and provided to you. Those USB drives will then be uploaded to a computer that has been secured for you at the jail for you to access all of that information.
Okay. My question is, was a notice of hearing posted or mailed to anyone to where apparently the news crews obviously got it? How is it that I do not know anything about this other than my bunk being kicked at 3 o'clock in the morning telling me I have court?
Ma'am, I have no other way to get in touch with you other than setting the hearing, which was set yesterday once I received confirmation from the jail as to the processes for how this would work. And I understand that your case is important, and I want to move as efficiently, as diligently as possible. I know that you've been waiting for this information, and it took some time to confirm the process with the jail. You've advised me that you have very limited space. You have almost no privacy. You have a small drawer where you can keep some personal effects. We could not send all of those boxes with you to the jail, and the jail advised me that they cannot take all those boxes. A process had to be created to make sure, and this is the process.
The process that I was explained after speaking to a couple of sergeants, and I've been waiting for that, and I would much rather prefer a hard copy of these to where I can write on them as opposed to anything that's on a laptop.
I am unable to provide that for you. I have been provided the process has been provided to me by the Orange County Jail. I understand that's your preference, but I can't do anything more than what I've done right now.
I understand. And I have had other information given to me, which is why I've been waiting for the boxes for them. So I don't know, is this something that I need to pursue continuously still for me to be able to receive my hard copies? Because no one tells me anything.
I cannot answer that question because that may call for me providing you legal advice, which I am prohibited from doing.
Okay. Well, because I have no other way of contacting you other than in a letter, and it's AKA worldwide. So am I supposed to go back and speak to the captain and whoever else it is that I might need to speak to in order to receive these?
Again, I cannot answer that question. All I can tell you is that we will have a hearing on August 5, whereby which Prison Break Investigations will provide all of the information on USB drives. Those will be provided to a representative from the Orange County Jail who will place all that information on a laptop for you to use, and that's accessible for your use from 0800 to 1600 every day.
Right. Okay, so I guess I will figure that out, because if I'm up at 2 o'clock in the morning, I can't utilize the laptop, which is another reason why I was looking forward to the hard copies. So my other question is my time prorated for the time that I've been waiting for my discovery?
I'm not sure I understand what that means.
Will I be having additional time added, or will it be extended from the time period of me waiting for my discovery still?
I'm not in a position to answer that question. I don't know what it is that you're asking for.
My pretrial is supposedly set for September 24th, I believe it is. So obviously I will not be prepared. And obviously I do not know what I'm doing. And obviously I'm still waiting for my discovery. So for that time period that I have been waiting for almost 4 weeks now, will that be added to the time frame in order for me to be properly prepared?
As of right now, the dates are what the dates are, ma'am.
Okay, so I just missed a week, a month.
The dates are what the dates are.
So I also sent you, I believe, 5 motions. Have you received those?
No, ma'am, I have not.
They were mailed last week.
Then I have not received them yet. The last correspondence I got from you, ma'am, was received on July 8th.
5 motions I've mailed. They're probably sitting wherever else it is, considering it takes a day for you all to receive my mail, considering I'm right down the street from you all. So I have those also in order, which may change whatever information or anything that I'm trying to acquire in between now, the month less that I have in order to prepare for my trial. That's in October. So if you could keep an eye out for those also. I don't know who I'm supposed to ask. How did Mr. Lane come into any of this? Like, how was he called?
Mr. Lane has been your investigator in this case, and he was advised to attend this morning's hearing by virtue of being provided the discovery in order to digitize it so that you can have access to it.
The court contacted him?
I did not contact him.
Am I allowed to speak to him directly?
You can.
Mr. Lane, who contacted you in order for you to be here, please?
JA contacted you.
If I'm pro se and my own attorney, shouldn't I be included in all of this so I know what's going on and not a surprise hearing like it is again for the second time?
Ma'am, again, this is why there were benefits to being represented by counsel. The court has already identified in its 16-page order the reasons for why you no longer have those benefits.
Right. Which
It
is
makes
now
things
formed.
exceptionally more difficult, as I explained to you, in communicating with the court and communicating with the state attorney's office.
Isn't that what a certificate of service is for anything that's filed by anybody in the court?
There
That
was,
should be included in that.
ma'am, there was no certificate of service for setting this for today. This was coordinated by the JA. You were advised as soon as it was set yesterday.
It's just very odd to me that the news knew about it before I did.
Again, I can't speak to that.
And so nonetheless, my constitutional right to counsel is being forfeited on your behalf in the court. So now I don't get appropriate notice in preparation for me to be able to be here and doing what I'm supposed to be doing and act as and perform as.
I've already addressed the reasons, ma'am, for why there was a forfeiture and alternatively a waiver in the 16-page order that you were provided. Again, it's difficult to communicate with you based on where your current housing is. I'm not able to pick up the phone. The judicial assistant's not able to pick up the phone to communicate with you or send you an email to schedule certain things. And it leaves a little bit of a level of further complication.
How is it the news knows before I do?
You keep asking the same question and the answer is going to be the same. I cannot answer that question for you because I do not know.
Okay, but you do know it's harder for me.
I would agree with that, yes.
And you do know that you did not ask me any questions in regards to your order. You just read it straight off and never asked me what's what or how many with anything of it.
Ma'am, if you have questions, I can certainly try to answer them. I'm trying to facilitate you getting that information that you're certainly entitled to. And it took time for a process to be created by the Orange County Jail, as they had advised me. They do not have a place to store 2 banker's boxes of information, nor are they in a position to provide you physical copies. This is what I've been advised as the process is. As soon as that process was finalized, I set the hearing. This was finalized yesterday.
No one ever asks me. I've been waiting for the boxes. I really don't know what to say. And because I supposedly have no way to contact you other than a letter, and the same for you, I don't know how the news crews got here before I did. But I don't know going forward, how is it that I'm supposed to be able to communicate with you other than me sitting here in front of you at these, I guess, supposed surprise hearings that I'm going to have every single time that it is that you would like to speak to me? Is that what it's going to be?
Ma'am, I cannot answer that question. All I can tell you is that you can communicate with the court through the avenues that you've been utilizing previously by and through letter writing. As I said, I do not have your letters that you sent last week. They're not in the court file, and they were not in my inbox yesterday. So as soon as I receive them, I will diligently review them. And if we have to set a hearing, you'll be properly noticed for it.
And the certificate of service.
You'll be properly noticed for it. Yes, ma'am.
And will there be a proper notice for today?
Notice was performed last night. I've already explained.
Ask the news crews how they got here?
No, ma'am, I'm not going to let you do that. They're not under oath. They're not a party to this action right now.
It's wrong and it's unfair.
You certainly entitled to that opinion.
Am I allowed to ask him a question?
Sure, go ahead.
Mr. Lane, how is it that you and I are supposed to be speaking to one another?
So my suggestion would be, since you're now the attorney and you are pro se, that either you or your honor gives me access to the jail to come visit with you, and I'll be happy to do that. It is the policy of the Orange County Jail to have a letter representing from an attorney to allow me to access you. That's the reason for the past previous couple of attorneys I've not had the ability to come out and access you, but that's changed. And I'll be happy to continue to move forward with any investigative actions I can do for your defense, as long as I get that access.
So you need a letter from me.
Or the judge or the jail, somebody that will allow me access to you. Yes, ma'am.
And I send it to you directly?
Yes, ma'am.
Is this a letter also that you'll be supplying to him?
I don't know that I'm in a position to compel the Orange County Jail to do anything.
But you are the ones who contacted him.
But I can't tell the jail, let this person come talk to you. If they have a policy where you need to provide the letter, then you need to provide the letter.
Figure it out, Sarah.
So until you have that letter, you and I will be able to speak with one another?
I will contact the jail myself and find out if there's an extension for pro se, or maybe they can speak to you directly to certainly get the actual letter itself.
Thank you.
Ma'am, do you have any other questions?
I don't think you have enough time. I'm just doing my best, and if you could please keep an eye out for my motions.
I will be on the lookout for them. You said there were 5, correct?
Yeah.
I will be on.
If you could please include me on the certificate of service for whatever hearings that we have that are no longer a surprise for me, please.
Understood. You'll be given a copy of the court's order that I read momentarily, and I will see you both on August 5 at 8:45 in the morning. All right. Thank you all very much. Mr. Cacciatore, anything further, sir?
Nothing from the state.
All right. Thank you very much.
Ooh, that was loud for y'all.
Thank you, sir. Have a great day. Oh, wait, before you leave, that is all going to be yours. Yes, I would, sir, so that you can begin the digitization process. All right. I'll see you on the 5th.
What is she telling her? Not to push her?
Perfect.
What'd she say?
Thank you, sir.
Let me back that up a little bit. Just a touch. Let me see if I can. I want to hear what she says to the bailiff.
The digitization process. All right. I'll see you on the 5th.
Consequences,
Perfect.
Sarah.
Thank you, sir.
Consequences.
Yes. Yeah, I'm just.
She is not happy. Did you see that guard talking to her? All right, I'm going to have to stream this live because I need to download it and increase the volume on what she was saying because there's no way for you guys to get the best on this. Is this the court reporter interviewing her? Not the court reporter. I meant the court, like the media reporter. Sounds like she's answering questions, though. It looks like that. Kelly. Mr. Lane, the investigator, he's like, oh, hell no. I think she's just answering questions. That's not a court reporter. I mean, a media person. Because, you know, she'd be just talking and talking and talking and talking if it was. It's going to be a bumpy ride. It sure is, psychic. She is so rude to the judge. It kills me. It just kills me. And she's asking questions too. So Abby can't believe we're going to court. Abby's like, is it really happening? She is such a victim, Tracy. Her whole life, she's been
looking rough.
She's always the victim. Every time she comes to court, she looks worse and worse. Okay, that's it. Let me pull that off. I'll replay it so you guys, if y'all came in late, you can watch it again. So they're going to give her a laptop with USB drives. I don't think she's going to get Wi-Fi. Maybe she has to get Wi-Fi, though. I was thinking about that. Maybe they have to get her Wi-Fi because technically she won't be... They got to cross all their T's and dot their I's on this one, you guys, because we're already treading on scary water here. You know what I'm saying? Like, I just feel like something's going to happen in appellate court with this thing because well, first of all, she's not going to shut up. We know this. She is digging her own grave. Yes, we know this, but she's very noisy. And I guarantee you she's going to try to get some like political figures or something involved. You just don't ever know. All right, let me go back and replay this. And I'm going to pause it while I'm playing it, so don't get mad. Hold your hat. Hold your hats, everyone. Suitcase Sarah Boone was back in the courtroom this morning. Let's see what happened. I didn't even know this. I didn't see this on the docket. Did you see this on? I didn't see this on the docket. 7:25. This was not on the docket. She's in a state of confusion. I just don't. She's got to have very few friends in prison. I don't know how she's not getting her butt beat right now. I know that's horrible to say that, but think about it. The way she is, the way she treats everybody around her, it's like how. Of course, maybe she's learned some things in prison. She's learning to be tough, I would think, but she needs to remember not to take that out on the judge. I mean, the man does have a lot of power in this situation, and she needs to remember and think about that. It's just common sense. It's something that, she should know that since she excels in everything. Good gracious alive. Well, listen, everybody, I appreciate you for being here. If you missed the portion of the court hearing, just rewind it back. We played it twice because we just could not believe our ears. I want to thank you all for being here. Have a wonderful day. Stay blessed. And I've got a couple more. I'm going to go ahead and put together all of the interviews in her case that they did with the friends and I think the brother. And also I'll redo the one with her husband. We already did it one time, but I'll put it in there too. I'll put it at the end so that you guys can go back and listen to that in between now and August 5th. Okay. Be good, everybody. Stay well. Thanks for watching, everyone. If you enjoyed this video, please do not forget to like and subscribe on your way out, and feel free to leave a comment. Have a blessed day.